Well, happy Friday today, and welcome to our webinar this morning, What Elder Law Attorneys Are Advising Clients in 2020, presented by Elville and Associates President and Principal Attorney Stephen Elville. For those of you who don't know, my name is Jeff Stauffer, Community Relations Director with the firm and Executive Director of the firm's charity, the Elville Center for the Creative Arts. We're coming to you live this morning from our Columbia office and are pleased to be with you today. How this will work, if you're not familiar with it, you are on mute. However, if you have questions, and we do encourage questions, please pose them throughout the presentation, and Steve will pause periodically to answer them, along with leaving time at the end for more Q&A. You also received the presentation by email yesterday afternoon from me for your convenience to take notes on it if you wish. Everyone will also receive a brief survey immediately after the presentation, so please just take a couple minutes to fill this survey out. That's going to offer us valuable feedback about the presentation. Let us know if you have some topics you'd like us to offer for future webinars. And also, it's a good time to request a time for a consultation with Steve if you have items to discuss for your family's planning needs. Briefly, for certified financial planners, CPAs, and other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. If I don't have it already, for my records and per the requirements of the CFP Board of Standards, please email me your board ID, and for CFPs only, I need the last 4 digits of your social security number as soon as possible. So very briefly, an overview about our firm and a bit about Steve. We were founded in 2010 in Columbia by Principal and Lead Attorney Stephen Elville. We have a number of different practice areas here at the firm and services that we offer, including estate and special needs planning, elder law and elder care planning, estate and trust administration, also focusing on asset protection, guardianship, and other litigation matters, as well as tax planning. We have 6 attorneys, 12 staff members in 5 different locations. And our mission, as it always has been and it always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. And we focus on education a lot here at the firm, as you have come to know. We offer that through our planning processes with our clients. We offer well over 100 educational workshops in the communities we serve each year. And also we have an accredited client care program through the Client Care Academy in Boston, Massachusetts, the only firm in Maryland to have that accreditation, which we're very proud of. Many clients take advantage of that and all the benefits that come with it. So we encourage you to take a look into that a little bit further. A little bit about Steve before we jump into our presentation. So Steve's a very experienced attorney, having been in the area of law for over 20 years. His work is centered in elder law and special needs planning and estate planning, with an emphasis in the areas of tax planning and asset protection. He's a member of many different membership organizations and professional organizations. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. He's a seasoned speaker, presenting at about 75 different webinars and workshops, conferences, and continuing education events each year. He was also named to the Maryland Super Lawyers list for a 5th time in 2020, and a couple years ago had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, our firm's charity he founded in 2014. So very proud of our charity here that Steve founded, and I'm very privileged to be the director of that charitable organization. Let me know if you have further questions about that. So our firm works every day with the ideals of client education, collaboration, and compassion in mind with our clients. And you should expect that from us anytime you partner with us in any capacity. So let's start off with a brief poll, and then Steve is going to jump into the presentation to get you comfortable with participating. And that poll is centered about around your experience in elder law. So the question is, elder law encompasses many different fields of law, and it's typically defined by the client to be served, which is typically a senior. So the questions are, what is your experience in elder law so far? So it's going to launch. And you should see that on your screen right now. Choose the best answer that applies to you. And the choices are, I have engaged in an elder law consultation before. I have not taken part in an elder law planning yet. I may have but don't realize it. Or I'm an advisor seeking to gain knowledge to serve my clients today. So just take a second or so to vote there. I appreciate your feedback. Looks like we're collecting responses. It looks like we have a varied group here so far, Steve. We'll just take another few seconds here. And it looks like the responses, we have 30% saying I have engaged in an elder law consultation before, 25% saying I have not taken part in elder law planning yet, 15% saying I may have, but I might not have realized it, and 30% saying I'm an advisor here seeking to gain knowledge to serve my clients better. So thank you for participating. We appreciate it as always. Gives us an idea of who our attendees are. And without any further things being said, I'm going to turn it over to Steve. And Steve should see the transition to him being presenter on his screen right now. There we go. And I'll turn my camera off so I'm not a distraction.
Thank you, Jeff, and good morning, everyone. Jeff, I just want to check in real quick. Do you see my presentation on your screen?
I do. Looks good.
Very good. And I'm going to see if I can move it forward, which I can. Very good. Thank you, Jeff. And good morning, everyone. And thank you for taking time out of your busy Friday morning to attend this workshop. I'm Steve Elville, and I thank Jeff for being our moderator. Jeff is quite experienced, so if you have any questions or concerns during the presentation, please let Jeff know. He's not quite as old or good as Bob Barker was in his prime, but Jeff is a wonderful moderator, so thank you, Jeff. And I'm looking outside my window here at the office. It's a beautiful Friday, and I hope you're planning a wonderful weekend ahead. Many of you hopefully have been able to take some kind of vacation during August, the big vacation month. But if not, if you're like me and you haven't been able to get away, I hope you will definitely be able to do something for yourself here at Labor Day coming up. So this morning, many people have questions about elder law. And I've been very blessed to be an elder law attorney these last many years. And one of the things we do here at Elville and Associates, and one of the things I've talked to my colleagues about in the elder law bar in Maryland, is really not just to provide information to people who are really eager to get this kind of information, but to give them solutions, to give them next steps. So that's what we're known for. And I'm hoping today through this educational workshop that you're not only going to know 95% more than anyone else you know about what's going on in elder law in 2020 in Maryland. I'm hoping you're going to have some kind of idea of the kinds of solutions there are available and how to take the next steps to do that. So that's what we take pride in, and along with counseling and education. So with that said, we're going to get right into the presentation. And as Jeff mentioned, please ask questions. I will be taking a little break in between to see if anyone has questions. And if not, we'll just keep moving through the material. Many people come to elder law workshops or even estate planning workshops, and they have questions. They have questions that they've been thinking about for years, or they have a situation going on in their family. We find that to be the case, and that's why we want to answer questions today as we go through. The other thing is, many people have engaged in what I would call conventional estate planning. They've come in or they've done wills or trusts and powers of attorney during their lives, and now situations may change, and we're going to talk about that. Situations have evolved in life where there's health issues or concerns about financing long-term care. So this is the impetus of which we're going to talk about as to where elder law becomes more of the focus sometimes than traditional estate planning. So elder law, how would we define that? Elder law, in my opinion, is a relatively new field from the mid 90s. I had a client yesterday that said, Steve, please don't call it elder law, call it senior law. I just don't like that word elder. But that's a common term of art today as elder law. So I'll use that term. So elder law is estate planning for people who are getting older with an emphasis on disability planning, long-term care planning, asset preservation in the long-term care context. Of course, we concern ourselves with tax planning and elder law, and we have to be mindful of that, especially income tax planning. But elder law is really nothing more than estate planning for older people, people who are trending older, or for people with disabilities, including special needs, with an emphasis not on just the traditional concerns, estate tax, how am I going to leave my assets to my loved ones? Of course, we want to consider all those things, but with an emphasis on long-term care, disability, special needs, and so forth. So with that said, let's talk about the trends in Maryland. Well, Maryland is traditionally what I would call obviously a Democratic or liberal state. I only mention those politically related terms as they relate to elder law, in the sense that Maryland has always been fairly non-traditional, in the sense that it's been somewhat progressive, but we still have a long way to go in the field of elder law as far as Maryland truly being progressive, or as progressive as some states are. Now, we do have expanded Medicaid. So many of you are familiar with the Affordable Care Act and the federal laws that have been expanded since the Obama administration. And Maryland for Medicaid is an expanded Medicaid state. But we still have major problems when it comes to taking care of people who are aging. And we see these problems every single week. I'm going to get right into those issues here. So we have major problems with what we call the waiver slots. And for those of you who have heard me speak about this before, you know that trying to understand this is about as clear as mud in some cases. So I'm going to take just a second here, and I'm going to be very, very general to set the stage for us to understand what I'm talking about waiver programs and waiver slots. So in Medicaid, if we're thinking in terms of Medicaid, which Maryland calls medical assistance, I want you to think in terms of these three simple categories. On this side, I want you to think, if you have a piece of paper, I would draw a column on the left side, and I would put community-based Medicaid, community-based Medicaid. If I am impoverished or I don't have a lot of income and I live in the community, I can get community-based services through the social services system of Maryland. I can get food stamps, I can get medical care, I can get those kinds of things in an unlimited way, community-based medical assistance. On the right side of your paper, I want you to draw a column and think in terms of long-term care, long-term skilled nursing, long-term care skilled nursing as in a nursing home. If I'm in Maryland and I have qualified for long-term care medical assistance, my income and assets are qualified, whether I'm single or married, I can get long-term skilled nursing care in Maryland. If I meet the rules, I can get that on an unlimited basis. So on this side of the coin, I can get community-based Medicaid if I qualify, unlimited. On the long-term care side, I can get long-term care skilled nursing, unlimited. But in the middle category, I want you to draw in or write in waiver programs. And there are many different waiver programs. There's an autism waiver, there's a traumatic brain injury waiver, there's an adult daycare waiver, there's something called the community options waiver, and that's what we're going to focus on. This used to be called the older adults waiver. It's now called the community options waiver. And what that means is if I'm in an assisted living, or if I have a relative who's in assisted living, not skilled nursing, but I'm in assisted living, and or if I'm at home and someone's taking care of me, or I'm taking care of someone else in my home, there is no Medicaid program, generally speaking, that is going to pay for that. So Maryland has a big problem with this waiver situation for the community options waiver because it's so limited. And many of you are familiar with this, but if you're not, here's the problem in Maryland. We are one of the worst states in the country for our waiver programs, as far as the waiver slots for older adults. We are in a situation where at any given time, there are 23,000 to 25,000 people on the waiting list to get these slots. There are only about 5,500 slots total available, which is way too low. And there are only about 3,800 or 4,000 of those 5,500 slots filled. So if you want to know right away, what are some of the big problems in Maryland and elder law, it has to do with this limited number of waiver slots. So if you want to be more proactive about this, please let me know. Please let me know that you would like to speak to your representative or legislator and from your district about this, because Maryland is basically asleep on this issue. There's been a little bit of progress thanks to some very proactive elder law attorneys in the state that need and deserve credit for that, but we have a long way to go. So where I'm going with this is community-based Medicaid unlimited, long-term skilled nursing Medicaid unlimited, but the waiver slots are limited. The federal government says to the states that the states can limit this particular benefit. So that's why we have people in Maryland that need these waiver slots and can't get them and have to consider moving to other places like Delaware or New York or Florida, as extreme as that may sound. So the trends are, well, we have a couple of good things going on here, but those waiver slots are probably the biggest problem we have. The augmented estate. Now, this is a complicated subject, but I'm just going to give you an example of what this is. So I'm switching now from a very negative trend that we can't seem to solve our waiver slot problem in Maryland, but we have solved one major problem, and that is how can we plan between spouses? Let's pretend we have two spouses and one of them is not well. One of them has an impairment or a long-term illness. Well, there are techniques that can be used in elder law to plan for how to leave assets between spouses in a very protected way. So the good news is the augmented estate legislation, which is quite broad, and it's too much to go into today, and how it affects spouses. The one good aspect of it is that the state of Maryland and the legislators and the people who wrote the law, they compromised with the elder law bar and basically said that if a well spouse dies first, and of course we would normally think in terms of an ill spouse dying first, but just in case a well spouse dies first, that spouse can leave assets to their surviving disabled spouse in a way that's not only protected, but the state of Maryland would have no right of recovery for Medicaid purposes, and those assets could be protected. And then that ill spouse could qualify for Medicaid if they needed to. So the augmented estate legislation is quite broad. If you're not familiar with this or haven't heard about it, you need to know about it for general estate planning purposes. But there's an aspect of the augmented estate law that has to do with elder law that's very, very much favorable to couples. So for married couples, this is really good news about how you can protect your surviving ill spouse should you die first. Cost of care. The cost of care, of course, continues to go up in Maryland as in other places. It's not unusual to see skilled nursing costs of $14,000 to $15,000 to $16,000 in some areas of the state. I strongly urge you to work with your collaborative team if you haven't done so, or to get a collaborative team, an elder law attorney, a CPA if you don't have one, a financial advisor if you don't have one, and look at the hybrid products, either a long-term care product or a hybrid long-term care product that your financial advisor can discuss with you, or to look at life insurance with a long-term care rider, or some kind of strategy to pay for the cost of care, because clearly that is not going to go down. That's continuing to go up. Income is something that continues to be pretty much the number one thing in elder law. I've always said this: the ability to have fixed income, or to be able to supplement that, of course, with long-term care insurance of some kind, but income and the production of income over the long term once someone has long-term care issues. So again, if you don't have a lot of fixed income, but you have some investments, I strongly recommend that you work with your financial advisor. If you don't have a financial advisor, let us know, and we can refer you to several financial advisors that can help you think in terms of how to deal with projections over a long term to deal with the cost of care. Elder abuse is still going on, as you well know. So the attorneys in Maryland and the Attorney General continues to deal with this issue of how to get elder abuse under control. I think a lot of progress has been made here, but still a long way to go in protecting seniors. Supported decision making. Supported decision making is a trend. I still think we are 2 to 5 years away in Maryland of having a supported decision-making piece of legislation that will pass. But for those of you who are not familiar with supported decision-making is an option where a disabled person can appoint a supported decision maker to help them make their decisions. Now, we may think that this is already happening, but it really isn't in Maryland. Delaware, the District of Columbia, Indiana, Texas, Wisconsin, and Alaska have supported decision-making laws. Very few states, of course, have this, but Maryland is right in between Delaware and DC and does not have supported decision-making. What does this mean? It means that if I am a disabled person, there's a lot of biases against me, that I can't make my own decisions, or that I'm not competent, or that I need a guardianship. So right now, Maryland has the old paradigm, the paradigm of, well, I either have the capacity to sign power of attorney or advance directives, or I don't. And if I don't have the capacity, I may need a guardianship of my person and property. And we know if we have a guardianship of our person and property, we lose our legal rights. So supported decision-making basically says this in so many words: I should be able to make my own decisions to whatever degree I have the ability to do so. I may have disabilities, but I do have some level of ability to make my own decisions. So I should have the right to appoint someone to help me do that. So a supported decision-making agreement can be for someone who has a power of attorney, they have capacity, and they also appoint a supported decision maker. Or in some states, a person could be under guardianship and still be able to appoint a supported decision maker. So we are hopeful, along with several attorneys who are spearheading this effort, to hopefully get a supported decision-making law in Maryland in the next several years, hopefully sooner than later, because many, many people are anxiously awaiting being able to appoint a supported decision maker. I happen to be lucky to be involved in a project right now, a documentary film project about supported decision making, and we are calling that film Championing the Voices. Championing the Voices. If you're interested in finding out more about that project and getting behind the effort for supported decision making, or if you're interested in getting behind the idea of getting more waiver slots and talking to your legislators, please let me know and we can give you more information. All right, so that was a lot, and we're getting started here in our next slides. So why are clients coming to see elder law attorneys in 2020? Well, as I mentioned at the outset, of course, we have age-related issues. Someone could be in their 40s or 50s and do estate planning, very conventional estate planning, and then over time, as they're updating their estate plan, there may be issues that are arising. A parent that has long-term care issues, a child, or the person themselves needs to come in and talk about a spousal situation or a situation affecting themselves. We are seeing all kinds of issues, as you are well aware, of early onset dementia and those types of issues, Parkinson's, other types of issues that are happening that are sometimes age related. Now, I will say in conventional planning, a couple comes in, or a single person, and they could be in their 50s or 60s or older, and there's a lot of discussion about traditional kinds of planning. And I want to say that I think a good trend is for attorneys to make sure that even where someone is coming in and they have not yet experienced these age-related issues, that the elder law type issues should be discussed at some point during that conventional discussion. So I do think that's important. Pre-crisis planning. Let's say we have a healthy couple or a healthy individual. They come in for some kind of estate planning, or they've just come in because they're curious. They've heard or read articles about guardianship, or they've read articles about what happens if someone has a long-term care issue. So they say, what can I do in advance of a crisis? I want to do pre-crisis planning. I want to do something to preserve my assets. So there are people who are strongly motivated to preserve their assets, and they come in for what I would call a pre-crisis conversation. This kind of thing is usually 5 years, which is the Medicaid look period that many of you have heard of. This is usually 5 years in advance of a crisis. So I will call that a pre-crisis conversation. And as I mentioned earlier, a change of circumstances could have occurred. It could have been something that was gradual, or it could be, God forbid, something that is more in line of a crisis, as we have here, like a stroke, or something that has rendered someone extremely disabled and in need of skilled nursing care. Or maybe it's not skilled nursing, but just we've got an issue now where caregivers need to come into the home, or maybe it's more affordable to actually go into assisted living. So these tragic situations or a pre-crisis situation are still the things causing folks to come in and say, what can I do? What are the issues? And that leads us on to a further discussion here. Healthcare decision-making, these are the issues. Financial decision-making. So let's go back to healthcare decision-making. This is one of the most important things that we can discuss, along with the MOLST laws, medical order for life-sustaining treatment. So healthcare decision-making, again, huge, not only for the mechanics of how to make healthcare decisions and making sure we have made those decisions in advance ourselves, but understanding MOLST and understanding our rights as agents. What if we've appointed agents and those agents don't really know how to do their job? Then they're not going to be effective advocates. So healthcare decision-making, financial decision-making, understanding the scope of financial duties, in-home care. What happens if we're having caregivers come into the home? How do we manage those people? Have we talked about the insurance issues and the liability issues and the tax withholding issues? And how are we going to get those caregivers in the home on a regular basis? People have problems and they can't come to work. Who's going to manage these people? Nursing home placement and assisted living placement. This is a huge issue for many people. Many people have a misconception of how one gets placed in a nursing home and the kinds of nursing homes that are available, even if we don't have the ability to pay privately. Estate planning, getting those foundational documents in place. This is one of the most important things we can do. And as attorneys advising clients, this is the most important thing that they can do, is get foundational documents in place. Powers of attorney, advance directives, wills, getting those things in place. Why? Well, if we don't get those foundational documents in place, especially financial powers of attorney, then we have a problem. We may have no flexibility as we age or as we have problems in elder law, and we may not have the ability to do or maneuver or be versatile, and we may be stuck with a guardianship or stuck with an older power of attorney that is very limited in what it allows the agent to do. So I hearken back to maybe 2017 when I went to the Heckerling conference, which has nothing to do with elder law, and I heard one of the leading estate planners in the world utter these words, that the financial power of attorney is the most important document, or arguably the most important document in estate planning. And I would definitely say, my opinion is definitely in elder law, the financial power of attorney, as simple as it may sound, is probably the most important document. Asset protection. So we talked a little bit about this, and we're going to talk about it more. Asset protection comes in various varieties, different varieties. There can be lifetime asset protection. There can be asset protection at death. There can be domestic asset protection, like the big states like Delaware and Nevada and South Dakota. Or there can be long-term care or elder care related asset protection. And that's what we're going to talk about today. We talked about understanding and limiting liability when we have people coming in our homes and so forth. We talked about assisted living contracts, or we're going to talk about that, nursing home contracts, and continuing care retirement community contracts. These things are extremely important to review before we enter a facility. And Jeff, I apologize, down here at the bottom of my screen, I'm running out of room, but we want to talk about Medicaid, of course, which is called medical assistance, Medicare. And Jeff, I can't read the last slide, so I apologize about that.
That says special needs planning, Steve.
Thank you, Jeff. So these are all the types of issues that are being discussed. And Jeff, I'm just going to stop briefly to see if we have any questions.
Sorry, no questions at this point, Steve. I think we're going to keep moving forward.
All righty. So what is an elder law consultation and what is it all about? So all of those issues I just talked to you about, whether it's pre-crisis planning or whether it's crisis planning, it involves basically being able to get at the real facts or the real underlying policies and the laws so that clients can stop being confused. So I don't know if you've experienced this yourself, but I have experienced it many, many times, unfortunately, where a couple or an individual is extremely confused. They are having some kind of an elder law related issue, and they are told many, many things that are untrue by hopefully well-meaning people, but these people are causing so much confusion and stress. People are told if they have an ill spouse, well, you're going to lose your home. You're going to lose your assets. You're not going to be able to pay for the cost of care. You won't be able to get your spouse placed in the right nursing home. All of these things are myths for the most part and untrue. So what the elder law consultation does, it involves really the fact finding and listening process. We identify problems. This usually takes about 2 hours. We want to identify the client's goals. So elder law, just like estate planning, is all goal driven. We look at the incapacity related issues. Remember, I said the financial power of attorney was probably the most important document in elder law. We're looking at that and we're saying, can we get all of our basic documents updated? Is the ill spouse or the ill person, do they have the capacity to be able to update their documents? So we give an overview of medical assistance. What does that look like? Asset protection techniques. What does that look like? We go over the cost of care and how in the world will this person be able to finance long-term care. We discuss a collaborative team or the advisory team. And as I mentioned at the outset, we make recommendations and next steps. We don't just give people information, we give them a path forward. And I think if you're an advisor on this call or another attorney, that is really, really important, not to just give people information, but next steps. Now, the elder law consultation is something that serves as a basis for a shift in the planning. as I mentioned, there's a lot of heartache and anxiety and hopelessness where a person is experiencing these issues. And so we're resolving a lot of ambiguity, we're resolving misconceptions, and we're providing a sense of direction and empowerment. And where we have problems in the family, which in some cases, not all families get along well, but if you do have a family structure where all the children and all the family members get along, you are very blessed, and a lot of good planning can be done. But if there are weaknesses in the family structure, we want to address those, okay? So this is what the elder law consultation is all about. If you or your client, if you are an advisor, if you have issues and they're festering and they're causing anxiety, this is where we start, the basis of all counseling for elder law clients. Now I'm going to say a few words about asset protection. So we've been going now for about 35 minutes, and I'm going to keep going. Asset protection, as I mentioned, there is lifetime protection, there's asset protection at death, and then there's long-term care asset protection. I'm going to focus mainly today on the middle category, but I also want to just cover the basics of these other categories, because I want you to know what they are so you can frame that. You have a frame of reference. So for lifetime asset protection, I'm going to talk a little bit here about married folks. If you're not married on the call today, I apologize. But if you're married in Maryland, you can own most of your property, except for IRAs. You can own that property as husband and wife or spousal tenants by the entirety's ownership between spouses. This gives a basic level of protection. Life insurance in Maryland is protected from the claims of creditors as long as a spouse or child is the beneficiary. The same thing for annuities, and I know many of you have annuities. Qualified plans and IRAs are protected from the claims of creditors. Domestic asset protection trusts, like I mentioned, Delaware Trust, Wyoming Trust, Nevada, Alaska, South Dakota. These trusts are protected in certain ways from the claims of creditors. But notice that for IRAs that are inherited, those are not protected from creditors, and we have to have special plans for how to protect those IRAs. So just know that a lifetime asset protection, we have a decent amount of lifetime protection, except for inherited IRAs. Now I'm going to stop just a second, and I'm going to digress because I don't want to forget to mention this. For inherited IRAs, where we have a disabled person, a person with special needs, let's say that person has inherited an IRA, and let's say that person has a special needs trust or should have a special needs trust. Uncle Sam allows for one exception that I'm aware of for an inherited IRA to be placed inside of a trust without triggering tax. So sometimes a person with disabilities will receive an inherited IRA and we don't know what to do with it. Well, depending on the situation that person has, if they're disabled, and depending on whether they receive means-tested benefits, we can take that inherited IRA and we can place it inside of a special needs trust with no tax. So I wanted to make sure I mentioned that. The other thing I want to mention about IRAs before it gets away from me today is that many of you are familiar by now with something called the Secure Act. The Secure Act is legislation that President Trump signed in December of 2019. It became law on January 1st, 2020, and it is pretty serious legislation in the sense that it's going to tax trillions of dollars of IRA money much quicker than it would have otherwise taxed it. And that beneficiaries prior to January 1st, 2020 could have stretched out their IRA minimum distributions for the rest of their remaining life expectancy. But now most people that are healthy and they are not exempt from the Secure Act, most people will not be able to do that. However, in elder law, if we are dealing with a person with special needs or disabilities, that person is exempt. That person is exempt from the Secure Act. And when they receive an IRA that's inherited, they will be able to stretch out that IRA for their remaining life expectancy. So that's important to know in elder law. And what's even more exciting about that, because there are so few exceptions, is that that disabled person, if they have a special needs trust, the special needs trust is also exempt. So when we are doing estate planning and when we are thinking about inherited IRAs or IRAs that we will be leaving to people who have disabilities, if that person is disabled, they are exempt. If that person has a chronic illness as defined by the code, that person is exempt, and the special needs trust for that person is exempt. So I wanted to make sure I covered that before we blew past the IRA portion. I'm going to go quickly to the next slide and then come back. Asset protection at death. This is something that's as strange as it may sound. Asset protection at death is easy to do. It's easy to do if we are planning with wills and trusts, whether it's planning in elder law. You may have heard at the beginning of this presentation that Maryland has just enhanced the laws that allow a spouse to die and leave assets to their disabled spouse and protect those assets from Medicaid recovery. Well, that same trust that is left for that surviving spouse is also protected from the claims of creditors, protected from divorce, protected from all kinds of fraud and abuse. So any kind of trust that's properly structured, that has spendthrift protection, we're not going to get into a lot of that today, but it is a spendthrift protected trust. And possibly we are going to use flexibility mechanisms like trust protectors. And we're going to think very carefully about structuring trustees. We're going to think very carefully about all that, but just know in elder law, as in estate planning, it's fairly straightforward to protect beneficiaries at your death from the claims of creditors, bad marriages, and other issues that might arise. I'm going to go backwards now to the real thrust of the presentation about asset protection today, and that is asset protection in the long-term care context. So when we have an elder law consultation, or when we're talking about protecting assets, we're going to look at this in tiers. And at the end of this presentation, I'm going to talk a little bit about those tiers, and hopefully this will make some sense to you as you ponder this after today's presentation. But remember, in asset preservation context, if we get ahead, if we get 5 years ahead of a crisis for Medicaid purposes, we can preserve, you can preserve 100% of your assets. We can use Medicaid trusts or veterans trusts, as we call them, Medicaid asset protection trust, to do several things. To make sure that we don't lose the cost basis adjustment at death, meaning that we get a step up in basis on assets to fair market value so that our beneficiaries don't have to pay capital gain. We want to make sure we don't lose that. So why would we use a trust? Well, we would use a trust to make sure we don't lose the step up in basis. We would make sure that the grantor of the trust, who is actually divesting themselves or giving up their assets into this trust to start that 5-year period, we want to make sure that that person has some little level of control over being able to change beneficiaries, control over being able to change trustees if they need to, which doesn't happen very often. But one of the biggest reasons to use a trust is to make sure that the beneficiaries' creditors cannot get at the trust assets. Let's say that a couple or an individual decides to divest themselves of assets for long-term care planning. What is their goal? Their goal is to get 5 years ahead of a crisis, to place the assets out of reach 5 years or more and not apply for Medicaid during that 5 years. So let's say they do that, but they don't use a trust. Well, first of all, they may lose the step up in basis. They've lost 100% control of the assets, and the claims of the beneficiary's creditors or the lifestyle or the issues that could affect the beneficiary now could threaten the integrity of the assets. Whereas if that person is using a trust, a properly structured trust with a spendthrift clause, let's say one of the beneficiaries has a divorce, and we've actually seen a case like this. What if the beneficiary has a car accident or is sued or is trying to be forced into bankruptcy? The claims of the beneficiary's creditors will not affect the grantor's assets. So that is one of the big reasons for using a trust. Now look down to the middle of this slide. We talked about using trusts under wills. This is a technique. We talked about the augmented estate, and we don't have time to go into it today, but the new Maryland law says that if a spouse leaves a trust under their will, which is actually provided in federal law from the early 90s, but if a spouse leaves a trust under their will for their surviving spouse, under Maryland law now, as long as that's done properly, Maryland will have no recovery should that disabled spouse ever need Medicaid. And at the death of the disabled spouse who was the survivor, then everything goes according to the will of the well spouse. Okay, so crisis planning, if we have to plan in a crisis, which many times we do, we did not have the chance to plan in advance. We did not have the chance to get ahead of the Medicaid system by 5 years. So now we know that under the current law, it's possible to save roughly 50% of the assets. We can't save 100%, but we can save 50%, and that is sometimes called the rule of halves. Life estate deeds are a simple method of being able to transfer real estate out of reach of Medicaid if we get up a 5-year advance life estate where we give up the power to sell. So this is sometimes a good idea. Sometimes it's so simple that it's actually a dangerous idea because it's an irrevocable transfer of remainder interest to children. So sometimes life estate deeds are too simple to make sense, and sometimes it's much better to use a trust. Jeff, I'm going to stop again just to see if there's any questions. We've been going another 15 or 20 minutes.
Thank you, Steve. We do have a couple. One question from a good friend of our firm here. If someone does set up a life estate deed on their residence, does that mean that they are taking the possibility of a reverse mortgage off of the table for the future? On the same points, if they have put in place a reverse mortgage, I assume they can't then set up a life estate deed.
That is a great question. I'd have to look at the individual situation, but I would say there are two types of life estate deeds. One is I retain a life estate. I can live there forever. No one can kick me out, but I can always sell my property at any time. That's called a life estate with power. I'm not so sure that a life estate with power to sell would be a problem. At my death, then all of a sudden everything goes to my children, let's say, my remainderment. But if I do a Medicaid type life estate deed, which is the life estate with giving up the remainder, the power to sell, and I'm giving the remainder interest, the moment I sign that, I'm giving away my remainder interest to my children, let's say, I think that would be a problem. It would be a problem to be able to secure a reverse mortgage. And I think if there was an existing reverse mortgage, that might be, and probably would be, a violation of the due on sale clause and so forth, because the person is giving away the majority of the value of the property. They are giving away the remainder interest, and they are only retaining a bare life estate. So I do agree with that, and I think that would be a big problem.
Thank you, Steve. And one more. If there is an opportunity to put an inherited IRA into a special needs trust, I would assume that the distributions would still have to be turned on and taken within the 10 years. I think you said that it doesn't necessarily have to be taken over 10 years. Also, certainly, as the assets come out, there are taxes owed, correct?
So yes, thank you for the question. Yes, as to the last part where taxes are owed, but I want to say that this wonderful thing where the IRS allows, and there's been maybe 15 or 20 private letter rulings that allow this, that the inherited IRA can be retitled and actually owned by the special needs trust. And I want to say this is not the typical third-party supplemental needs trust where is the typical bread and butter special needs trust that couples or individuals establish for their children. This is a first-party special needs trust that's approved by the Attorney General, where the disabled person is under 65 years of age, and it would be exempt under federal law, and the disabled person would be able to stretch it out over their remaining life expectancy, so long as the trust is drafted right. So the 10-year rule would not apply, and the IRA would be retitled in the name of the first party special needs trust.
Thank you, Steve. And one more. Aside from somebody saying this is awesome and very interesting, the question is the inherited IRA not protected from creditors true in all states?
That is a wonderful question. I'm going to say that I don't know 100% what that answer is, but I will venture to say my reaction is that various states have laws relating to IRAs. And so I'm going to say that you're right, that there may be states that inherited IRAs would remain protected under state law. But the Supreme Court ruled I'm just guessing, about 12 years ago now, that inherited IRAs are not protected under federal bankruptcy law. I'm not saying that certain state laws would not supersede that. From an intellectual, academic point of view in estate planning, I would take the position that because we don't know where the beneficiary is going to be living in the future, we just don't know these days. They could be living anywhere. So because we don't know where they're going to be living, I would take the conservative approach of leaving an inherited IRA to a spendthrift trust for the beneficiary if I'm concerned about asset protection.
Okay. I think that will do it for the questions for now, Steve. Thank you.
All right. Thank you for those great questions. It helps Jeff and I tremendously. Okay, so when we are inside the elder law consultation, what do clients want to know? Well, some of this will not be new to you, but hopefully you will, something here will trigger something new for you, or you'll use this as a tool in the future. How can I pay for the cost of assisted living or long-term care skilled nursing? Again, these are the issues that are just heartbreaking for those who can't really afford this. Or I'm going to say some people can afford it, but they have not thought through the issues of their fixed income, using their collaborative team to help them, and so forth. So this is one of the big issues. Will I lose my home? In most cases, the answer is absolutely not. So this is a myth for most people. How will I survive in the community? Well, great question there. For couples, for example, how will the well spouse survive in the community? The federal law allows, and state law allows for certain things. It's not grand, but it allows for certain protections. But as I was discussing with a couple yesterday, if we took this particular strategy versus this one, the well spouse would not have the income of the ill spouse anymore, because the income of the ill spouse will go to the nursing home. Less certain deductions. So that's a very valid question. How will I survive in the community? How can we preserve any of our assets? Well, we have to look at everything. Veterans benefits, if someone is a veteran of one of the major periods of war. We have to look at the production of income and the full analysis of fixed income. We have to look at what is the goal of the client? What is the level of care situation? What is the whole family like how is the whole family situated? How do I deal with the placement of my loved one? Many people wait way too long to place their loved one for obvious reasons. Unfortunately, sometimes the placement is so delayed that the caregiver spouse, if there's a spouse, is disabled themselves. So this is a big issue. Healthcare decision-making issues, making sure that the couple or individual understands it, and also making sure the family members or the agents understand it. Well, I need a guardianship. Well, no, we don't want that. We want to avoid guardianship, but if we're dealing with guardianship, we want to face that head on. Again, I talked about getting veterans benefits. Well, there's new rules. The October of 2018 is when these new rules came out. In some ways, the new rules are much better, that they allow most people to exempt more. And in some ways, the new rules are not good because they now cause a look back period for veterans benefits, whereas prior to October of 2018, there was no look back period. Asset titling questions. This is one of the major issues. Well, Steve, I've got everything titled with my 3 children. Well, that's not necessarily going to help us with elder law. As a matter of fact, it opens up all kinds of problems. What if one of the 3 children has a divorce or a car accident? Well, now you've just lost some of your money to a lawsuit. So we want to look at asset titling very carefully. And in strategizing with various elder law strategies, the titling of assets is critical. So arguably, how assets are titled is one of the most important things in elder law and estate planning. No matter how wonderful the documents are or whatever our strategy is, how the assets are titled. How do I deal with my impaired loved one? This person is being abusive, or this person is basically not functional, or I can't get them into the bathtub. Lots and lots of issues. How do we deal with that? Do we need to bring in a life care manager or a social worker to help? Do we need to have movers come in, or organizers to help us move and transition? We live in a continuing care retirement community. Can we still preserve our assets, or are we subject to the rules of the community, which in many cases that is the case? But we need to know that even if you're living in a CCRC, your veterans benefits, if you're eligible for veterans benefits, are still very valuable. These are the kinds of things that we are talking about. So what are the decisions clients are confronted with? Well, I might need to change my estate plan. So remember, most people don't update, and we want to strongly encourage people to update every 2 years, every 3 years at the most, especially if you're over age 60, to look at your powers of attorney, advanced directives, make sure you're in tune with changes in the law, make sure the documents are updated. But let's say someone has not updated all these years. Now we might have to have a major shift or major change in the estate planning. So we've got some hard decisions about health care. Well, I'm actually going to name my child to be my healthcare agent and not my spouse. That's a hard decision because some people have been married 50, 60 years or more. This is a tough thing to do. Is it time to place my spouse or my loved one? Is it time to transfer assets from me to my kids in some way? Or what's even harder sometimes, is it time to transfer assets between spouses? Because the ill spouse, let's say, arguably should not have assets in their own name for asset protection purposes. What is the level of care? And again, I talked about bringing in a geriatric or life care manager. What is the level of care we're dealing with here? One of the things I find is that most people who are dealing with crisis situations do not properly think about this level of care issue. And I think it's one of the most important things, along with the powers of attorney, along with the elder law consultation, to understand the level of care that your loved one needs, or the loved one needs, and where they should be living or where they can live under that level of care. So that's important to know what our options are. Now, as we start to get towards the end of the presentation, we still have a few slides left. I want to give you a general idea. Perhaps I should have said here the tiered approach and not the tiers approach, but I want to give you some ways of simple thinking about these issues because it's so overwhelming. It's so much. Sometimes people say to us or to me, how did you get your mind around all this stuff? Well, it took years, of course, and years of experience. So this is an awful lot to take in 1 hour or an hour and a half. But if I could leave you with something that would be incredibly important to know, it's that I would look at elder law situations like this. Number one, if we're dealing with an impairment, maybe it's not a crisis yet, maybe it's just a quasi-crisis. We have an issue, there's still lots of time, and hopefully the person with disabilities is not going to have a crisis anytime soon. They could live for years with these disabilities or with a long-term illness. What we want to do, as long as that person has mental capacity, we want to build maximum flexibility. If you look at that first bullet point there, that means getting the foundational documents in place. Nothing could be more simple. It does take time and effort. You could just sign a set of documents, but you want to know what they say. You want your children or other agents, brothers and sisters, nieces and nephews, you want them to know what these documents say. You want them to know what their powers are. And we want to build maximum flexibility. Now, I should have put a star beside this one. Maximum flexibility is not for everybody. Remember, not everybody has family members that they can trust. Most people are blessed and have that situation, but what if you don't have children? What if you're having to depend on a niece or nephew or a friend? So we may or may not be able to build the maximum flexibility. And what do I mean by that? Giving your agent the same powers to do things that you could do yourself, massive powers, powers to transfer assets, powers to be compensated, powers to change beneficiary designations, powers to create trusts. All of these massive powers, ideally, we would want these in a perfect world, but we may be in a situation where we can't build that in. But if we can, we want to. We want to address the costs of care and the potential costs of care, and we want full education, as I mentioned, not only for the client, but for their family members and their agents. So the first category is we're going to build in as much flexibility as possible. We're going to have a foundational plan for this married couple, but we're going to wait and see. We're not going to necessarily do anything more than that. Look at category number 2. We're building the same thing as we did in category 1, but between spouses, we're going to transfer assets. We're going to transfer assets from the ill spouse to the well spouse. Now, of course, this is very, very touchy issue. I find that with proper counseling, most spouses where the ill spouse still has their mental capacity, this will be something they understand intuitively should be done. Because we know if we leave assets in the disabled spouse's name and they were to survive, let's say the unexpected happened and they were to survive, now for asset protection purposes, we've got a disaster. The ill spouse now has all the assets in their name. We could still possibly save up to 50% of those assets from a skilled nursing home spend down, but in theory, they might be out in the world and others, meaning people out there in the world, will tell this family they have to spend all of the assets down to zero. So this is a risk. So we don't want the ill spouse ideally to have assets in their own name. Now, what if the ill spouse has IRA assets or 401k assets, and they're not small, they're moderate or large assets? Then we're not going to be able to move those out of that person's name without taxation. So if it's a traditional IRA or 401k. So non-retirement assets, we want to move out of the name of the ill spouse. So the difference between category 1 and category 2 is in category 2 between spouses, we are transferring assets out of the name of the ill spouse to the extent we possibly can. 3, what if there's a pre-crisis situation? Well, we might gift assets outright, or more likely, we're going to gift assets in trust for all those reasons we talked about earlier, preserving the step-up in basis, controlling the assets to whatever extent the grantor can control them, and keeping the assets protected from the claims of the beneficiary's creditors. That's a pre-crisis plan. not everybody wants to transfer their assets. You have to be strongly motivated to transfer your assets or a portion of the assets, but that is a pre-crisis plan. And then, of course, in crisis planning, we are preserving assets for the well spouse, okay? So with a married couple, it's important to know that if we've at least built in that maximum flexibility, or at least a moderate amount of flexibility in the foundational planning, if the couple has done nothing else and one of the spouses goes into a nursing home, lots and lots can be done, much can be done to preserve assets for the well spouse, and in some cases, nearly all assets can be preserved. So this is the truth of the matter and not the myth that most people are under in a crisis like this that is so devastating. I'm going to lose all my assets, and that is simply not true with proper counseling and representation. Now, for the unmarried person, we have a similar situation, except we don't have the ability to preserve a lot of the assets, and I mean a majority of the assets, because Medicaid has pretty tough rules when it comes to an unmarried person and their spend down of the assets. So with the unmarried person, we can only exempt, in Maryland, $2,500. In some states like New York, it's much higher number, but for the single person, unmarried person in Maryland, we can only exempt $2,500 if we don't take other action. So for the unmarried single person who has a crisis, okay, they are evidencing a need for elder law counseling. We want to have those foundational documents, just like we talked about last time, full educational counseling. Sometimes this is more important for the unmarried person than the married person. Pre-crisis, we could still save the majority or maybe even 100% of the assets if we do pre-crisis planning. If we don't do crisis planning, if we don't do pre-crisis planning is what I'm trying to say, but at least we've built in the flexibility in the beginning. We can save up to 1/2 of the assets. So let's take an example. Let's say I'm a single person. I have 3 kids. I have $600,000 left in my name, and I have to go into a skilled nursing home, and the cost of care is $14,000 a month. Well, my children, who are my agents, they will take care of me. They're paying for my cost of care, and let's say they pay for the first 3 months, $14,000 a month, $14,000 a month, $14,000 a month. And in the third month, they come to the fourth month, they come into the conclusion that I'm not going to be leaving the nursing home anytime soon, and probably am never going to come out in that unhappy situation. What they can do is they can take protective action through the rule of halves, which is a strategy, and they can save approximately 1/2 of my remaining assets. So the rule of halves says, if I have a crisis and I'm a single person, through various techniques, which we can do these days under the current law, approximately 1/2 of the assets can be preserved. So a difference between the strategy for the married couple versus the strategy for the single person. Now, as we begin to work towards the end, I don't want to forget the importance of incapacity planning. I know I've been very redundant and sound like I'm beating this drum of the powers of attorney, but I cannot overemphasize the importance of the financial powers of attorney along with the healthcare directives in elder law. So remember that when we have financial powers of attorney, we are avoiding guardianship of our property. Remember, under guardianship, the court will look very conservatively at our assets and most likely will not allow any asset transfers. The money has to be spent down to 0 for our care. And in some cases, this is perfectly fine. But in cases where we want to preserve assets, this is not fine. So we want to have powers of attorney. And you'll notice here, I am illustrating the Maryland statutory power of attorney and the broader general power of attorney as a layered approach. And I'm going to talk about why the statutory power of attorney is not enough. We're going to talk about that in just a second. On the healthcare side, we have the advance directive, which allows us to name our agents. And remember, That avoids guardianship of our person. We do not want to have a guardianship at all because we lose our rights to our property and person. It allows you to make end-of-life decisions in advance. It allows you to decide when the agent's power goes into effect. It allows you to decide whether the agent has flexibility in the decision-making or not. It also allows you to make organ donation or end-of-life funeral arrangements or cremation arrangements, final arrangements. So these are very important. They are the foundational documents of elder law. Again, when you have agents, and I encourage you to appoint as many agents that are reasonable. When you have agents and those agents get along, those agents are not in conflict, you are going to avoid guardianship of your person and property. Now, I'm not going to go through every one of these slides, but these are for your educational purposes to show you why we would use more than just the Maryland power of attorney. In 2010, Maryland came out with the Maryland Power of Attorney Act. And the Power of Attorney Act was in response to a lot of fraud and abuse and basically some just very poor power of attorney laws in Maryland. So this is a very good thing in my opinion, but the statutory powers of attorney, and there's two types. One of them is a very simple form. That's a 5 or 6 page short form that many of you have seen. And one of them is actually a long form. It's actually 8.5 by 14. It's a long one. And that one is actually quite comprehensive. But the statutory forms themselves are not flexible. We are not supposed to change them too much, or they become non-statutory forms. And why is that important? Because if a statutory power of attorney is deemed to not really be in compliance with the law, then that power of attorney will fail and it will be void. So remember that the whole purpose of the statutory powers of attorney was to make sure that if you live in Maryland, you can have a power of attorney that actually works, and it would not be rejected by law if someone goes to use it on your behalf. Your agent goes to use it on your behalf. So the Maryland statutory power of attorney, in our opinion, is not very conducive to customization. So we would use the statutory form as the first layer for simple things, simple financial powers. But we would use a general power of attorney to build in those elder law related powers, those broad, flexible powers. So these slides that I'm going to show you here, which we are not going to spend a lot of time on, are talking about the various reasons why the simple statutory power of attorney is just not enough if we're doing advanced estate planning or if we're doing elder law related planning. So you'll see here that elder law concerns are not really covered in the statutory form. Planning for special needs is really not covered, okay? We want to build that big flat platform of flexibility, and we want to utilize special agent provisions, which we don't have a whole lot of time to go into today. We want to have customized powers. We want to have the ability to spend down for Medicaid purposes and deal with things that are elder care related. So I won't go through every single one of these things. I just want you to know that the simple statutory power of attorney is not enough in Maryland. And we want, you'll notice here, the power to establish a first party special needs trust. The person who asked the question about the IRA that was inherited and moving that to a first party trust. These powers are disability or elder related. Healthcare decision making is the most important document for some clients. As we begin to wrap up, we think this document should be customized. We want you to know that there is no set form. The Maryland Attorney General form that we recommend is recommended because it's simple, it's easy to read, it is recognizable in Maryland, DC, and Northern Virginia. It is put out by the Attorney General, and in theory, this is enforceable wherever you may be. Now, many clients will say, well, Steve, what if I move to Florida or Arizona or California? Is my Maryland advance directive still good? Well, according to the Attorney General, the answer is yes. but if I permanently was moving to Texas or Florida or Arizona, I would get new healthcare directives and new financial powers of attorney in that state. But back to the advance directive, we want you to customize it. We want you to think about it. We want you to include your preferences. We want you to think through the issues. If you don't want to do that, that's perfectly fine, and you don't have to answer any of these advanced questions. But remember, at a time of healthcare decision making or crisis, the advance directive, along with whatever you have said verbally to your loved ones or agents, is the only thing they really have to know what you want. So we want you to think about this thoroughly. There is a form on the internet called the 5 Wishes. Some of you know about the 5 Wishes. There's nothing wrong with that form, and there may be other forms out there. So there is no set form for the healthcare advance directive, and it can be customized. Again, we use the Attorney General's form as a general rule of thumb. The MOLST laws have been effective since 2014, 2013. If you are not familiar with MOLST, remember that MOLST is required in Maryland, the medical order for life-sustaining treatment. You can update yourself or educate yourself on the Attorney General's website that I list here. Remember that the MOLST form is not an advance directive. Remember that many facilities will not be paying attention to the advance directive these days, which is going to sound very panicky to some of you or make you panicky. I want you to know that the advance directive is still very important. Don't let anyone tell you it isn't, but you need to understand what the MOLST form is, and that if you go into a facility, you are most likely going to have one of these forms within 48 hours, signed by a doctor or signed by a nurse practitioner. You need to be educated. Your agents need to be educated about what this is. So as I wrap up, and I thank you for your time and attention, and we're going to take questions if there are any questions. We want you to know we're not just giving you information here. We want to be a resource for you, and we want to help you move forward with some of the concerns that you might have. So please, we want you to be encouraged to set an appointment with us. You can do that by letting Jeff know on this webinar, or you can send a message to my assistant that many of you are familiar with, Mary Gay Kramer. Her email is mary@elvilleassociates.com. Jeff's email is jeff@elvilleassociates.com, and you can email me as well if you would like. So that's one way to take the next steps about just talking about conventional planning versus elder care planning, or some kind of ongoing elder care issue you're dealing with or someone you know is dealing with. You can actually start your estate planning or elder care related planning by our interactive module that Jeff can send to you today. So Jeff will be sending that out to you so you can take a look at that and use it if you wish to start your process. Jeff also has an estate planning stress test, and that is basically a survey that is very introspective, and I think you might enjoy that. So Jeff's going to send that out. First steps are to complete an elder law or estate planning questionnaire. There's nothing to fear. We're looking at that questionnaire. It's private information. We're keeping it private. We're looking at it as the basis of the planning. So information to us is information that gets translated back into planning, and that's the basis of all planning. We want you to bring your current documents. We want to review what you currently have. You might not need an update, but many people are not tracking the changes in the laws, and sometimes it's a necessity to have an update. We want you to consider whether you have an advisory team, and we want you to have one. We want you to have a CPA. We want you to have a financial advisor. Now, some of you have done very well without a financial advisor, and I commend you for that. But once we get to a certain age, sometimes it's very important to have a financial advisor. We strongly recommend that you have a collaborative team. And this collaborative team could include an elder care, life care manager, or what we used to call a geriatric manager, or a social worker. So we know that this is something that enhances the life or the experience or the information and choices that you have. So we want you to prepare questions for a discussion. Please come in with questions if you have them. We're going to give you time to think We're going to give you time to think about what your goals are, develop that plan, develop those thoughts, determine who your trustees and other fiduciaries are. How do we approach this? How do we get from point A to point B? So I thank you so much. It looks like the sun is still out. It's going to be a great day, and I hope you have a great day and weekend ahead. And with that, I'm going to turn it over to Jeff and see if we have questions as he wraps up.
Well, thank you, Steve. We do have a couple of questions that have come in. So this is your time to put those last questions in if you do have them. So Steve, this is a question that you might enjoy answering. The question is, why does a planning team need a CPA?
That is a great question. I thank you for asking that question. My experience, and I can only talk from my own experience, I'm sorry that this is just from my perspective. From my experience, CPAs are the most trusted of what I will call the collaborative advisors or the advisory team or professionals. So I have found over the years that clients that have CPAs and utilize those CPAs, CPAs can be extremely valuable, and many clients trust them as their most trusted advisor. With that said, in elder law or elder care, many times we need to do, for a lack of a better way of saying it, number crunching. And CPAs can do certain kinds of forecasting. They can also help when it comes time to have to decide, well, do we really want to cash out this person's IRA? Or do we have to annuitize this person's IRA? And what are the tax consequences going to be? CPAs can be invaluable for those obvious reasons. So CPAs can really add a lot to the team. And again, I realize that all these advisors can represent out-of-pocket funds and money where you may not have had one in the past, but to my experience, and in my experience, CPAs can be worth their weight in gold, so to speak.
Thank you. Another question. So what is the preferred power of attorney that is recommended? Durable, for most reliable power of attorney?
Great question. So everything relating to powers of attorney is a counseling issue. So in a perfect world, we all would have powers of attorney that are immediately effective the moment we sign them. There's no proof of our disability required. When we sign that power of attorney, the power is effective immediately. Our agents do not have to jump through hoops to start to act for us. In a perfect world, we would all do that. On the flip side, many people do not want that. I had a client the other day that said, Steve, why in the world would I give someone an immediate power of attorney to immediately be able to handle my affairs? Of course, the immediate power of attorney is a good faith arrangement where we trust our agents implicitly, and we're intentionally causing them to not have to jump through hoops to act for us. There are people who want that, for particularly spouses. But for single people or people who are appointing non-spouses as agents, many times they do not want that. They want the power to be effective only upon disability, as proven by 2 physician statements. So this is a counseling issue. It's a family or individual by individual issue.
Okay, and the last question. So now's your time to get that last question in. We're getting close to 11:30. Is it preferable to get 2 doctors' opinions to determine mental incapacity under the advanced directive?
All right, and this is a great question, and I'm going to go back to what I just said. This is going to be an individual counseling issue. I find that when we are discussing advanced medical directives with clients, clients find this particular question that you've asked more difficult. Excuse me, I apologize. They find this one more easy to deal with than the financial question, because it seems that when we are dealing with healthcare decisions, that it seems to be easier to say, well, yes, this person can act for me immediately or only upon my disability. I will leave you with this thought. I think the person who says no proof of disability is required. I just want to make things easy for my agent. I think that person is a person who trusts their agents implicitly, and that person is not necessarily concerned about something I will call their right of self-determination. They just are not focused on that. Whereas the person who says, you can only make my healthcare decisions when you have proven that I cannot do it myself. That person, to me, is the person who says, you know, I think this is something that's so important to me that no one be able to make my decisions, even if it was in good faith. No one can make my decisions unless they prove my disability, because I want to extend my right of self-determination as long as possible. And I don't care if that's inconvenient or costly. What's important to me is extending my right of self-determination. These are the kinds of counseling issues for individuals that we go over. Whereas on the financial side, I find sometimes that it's much easier for people to think about this, because it's very easy to understand whether, does this person have immediate control over my assets or not? And so I find that people are much more conservative on the financial side about the proof of disability. But on the other hand, on the healthcare side, many people want to preserve their right of self-determination, even though in a perfect world, we would all give our agents power immediately. Many people do not go that direction. So I hope that helps a little bit to frame the counseling issue that you would be talking about if you're revising your documents.
Okay, thank you. And another one's got a couple of parts to it, so I'm going to try to read through this properly. If single, how do you protect assets if already have some form of Medicaid with disability benefits with Medicare early through disability? Is QMB different than Medicaid? Pays very little or minimum help?
Right. So that's a great question. And I'm just going to say that's a multi-layered question that's going to have to do with your individual disability situation. And I understand from the question that you are a qualified Medicare beneficiary, and I understand that that only pays for certain things. And it's also going to depend on whether you are actually a Social Security disability beneficiary who receives Medicare, but you also may or may not receive SSI. So that's a counseling issue and a fact-finding issue. And also, if, of course, you were receiving SSI or not, whether you have means-tested benefits that you're eligible for. Because even though you may be a Medicare beneficiary and a Social Security disability beneficiary, you may or may not receive other means-tested benefits. So that's a multi-layered question, and I would invite you to either make an appointment and we can talk about your specific situation. I apologize, I couldn't give you a more definitive answer because there are many layers to that question, but thank you.
Okay. Well, I want to thank you all for being a great audience. A lot of great questions as usual. I want to give Steve a virtual hand for a job well done. Really thank you for a great webinar. Just a few housekeeping items before we close out for today. We do have a few events coming up. Next Tuesday with partner Olivia Holcomb-Volke, we have estate planning for the surviving spouse. We've never had that webinar before, so looking forward to that. Next Wednesday, we have an estate planning essentials webinar, getting back to the basics with partner Nicole Livingston. For the advisors on the webinar today, we have our next advisors forum, as a reminder, coming up on Friday, September 18th in a few weeks. And we have formal invitations coming out for that within the next week. So as follow-up for me today, you'll be receiving a message with the following information. Many people ask for the videos for these events, and I'll be sending out a link to the video when it becomes available later today. I'll also send out a copy of the slides again. I'll also be sending a link to our interactive estate planning module which you can find on our website, but I'll send that link to you directly, and also a link to our estate planning stress test, which is an interesting exercise. It takes just about 5 minutes. It has about 15 to 18 questions, and it gives you a score based on 0 to 100. The lower the score, the better. That gives you an idea of, based on your current situation, if something were to happen to you with your planning the way it currently is, how stressed would your family situation be if you were no longer around? So it's a really interesting exercise, and I encourage you to take a look at it and take 5 or 10 minutes to take that test to see what your score would be and what action you might want to take based on that information. So trust you'll find these to be very valuable information and resources to you when I get those out to you. So I want to thank you, if there's nothing else, for a great webinar, and thank you to Steve, and thank you to everybody again for participating. Hope you have a great weekend.
Thank you, everyone.
All right, take care.